Hello, everyone. Thank you for joining us for this episode of Subro Sessions. Today's episode is titled In All Fairness, Discussion of Recent Court Decisions Finding Arbitration Clauses Unenforceable. I'm Gus Sara, and today I'll be discussing arbitration clauses in construction contracts. I know what you're thinking. This is probably going to be the most fun that you've had in ages. But in all seriousness, subrogation cases involving construction defects often involve contracts which include arbitration clauses that need to be addressed. So this topic is an important one in the subro world. I will focus most of today's episode on two recent court decisions, one from Illinois and one out of Texas, both of which held that the arbitration provisions in their respective residential construction contracts were unenforceable. Perhaps these decisions are a sign of things to come in other jurisdictions. Only time will tell, but they're certainly worth discussing. First, I'd like to discuss arbitration provisions generally, as they are very common in construction contracts. There seems to be a preference among contractors to avoid litigation and the uncertainties of a jury. For probably a variety of reasons, contractors typically prefer arbitration to litigation. And they often include provisions in their contracts which require any dispute related to the construction or the contract itself to be resolved through arbitration. These provisions usually identify the arbitration company to be used. They typically name American Arbitration Association, or AAA, as the entity that will be handling the arbitration. These provisions often require the number of arbitration panelists and set forth the cost allocation between the parties. Some of them require that the prevailing party not pay anything and that the losing party pay all the costs for the arbitration. I've seen many different variations, but I typically, in almost every construction contract that I deal with, I come across some version of an arbitration clause. So the first case I'll be discussing is Bain versus Airroom LLC. It's a 2022 decision out of the Appellate Court of Illinois. In this case, the court considered whether the lower court made a mistake in enforcing an arbitration clause in a residential construction contract, and as a result, completely dismissing the plaintiff's lawsuit. This case involved the plaintiff, Mary Bain, a disabled senior citizen who hired defendant Airroom LLC to renovate her home. The Airroom provided a standard written contract, which was titled Cash Sales Contract, and included, to no surprise, a binding arbitration clause. The clause required that any dispute arising or relating to the contract be resolved through AAA, American Arbitration Association, and that the arbitration would have to use the construction industry arbitration rules and mediation procedures, which are typically used in very complex construction cases. There are different sets of rules that the American Arbitration Association have, and some are less extensive and less costly than others. And this particular set of rules and procedures are used for more complex cases and are typically more expensive. Ms. Bain had issues with the overall cost and quality and timeliness of the construction work performed by Airroom, and she eventually filed a lawsuit. Airroom then filed a motion to compel arbitration, citing the provision in the contract. Ms. Bain opposed the motion, arguing that the clause was unconscionable because she lacked bargaining power to negotiate the terms or even understand the terms. She claimed that she was bombarded with a series of documents at the signing, including schedules and specifications, and was required to sign up to 48 pages, and she pretty much got lost in the shuffle. Airroom never mentioned the existence of the arbitration clause. They never specifically called it out and explained it to her. Ms. Bain challenged the clause because it prohibited punitive damages and awarded costs to the prevailing party, which meant if she lost, she would have to pay for the entire arbitration. The clause also prohibited award for attorney's fees, which is something that a claimant would usually be entitled to in litigation. The provision also prohibited the arbitrator from reaching any findings contrary to the express terms of the contract, which is arguably limiting the arbitrator's ability to actually make decisions on the case. There was also a strict confidentiality clause that Ms. Bain took issue with. The defendant in this case, Heirloom, argued that the provisions were standard. They were part of the contract that they used to sign hundreds of residential construction contracts, and that the contract was signed and by Ms. Bain, and she had an opportunity to review it. They also claimed that the contract was in compliance with Illinois' Home Repair and Remodeling Act. The lower court agreed. They found that the plaintiff had the opportunity to review the provision. The court found nothing wrong with the actual terms of the provision. As such, they didn't find that the provision was either procedurally unconscionable or substantively unconscionable. In fact, the court also ruled that the plaintiff was required to prove that the arbitration provision was both procedurally unconscionable and substantively unconscionable. So the court ended up agreeing with the defendant and dismissing the case. The appellate court found that the lower court made a mistake in requiring that the plaintiff show both that the provision was procedurally and substantively unconscionable. They ruled that the plaintiff only needs show one, either that the provision was procedurally unconscionable or substantively unconscionable. The appellate court explained that the approach that the lower court took was outdated and that the new standard has changed, making it easier for the claimant to prove that the arbitration provision was unconscionable. Here, the court found that the provision was substantively unconscionable because it prohibited punitive damages and attorney's fees. They also found the confidentiality provision to be one-sided and unfair, and that they overall thought that the forum with the applicable rules stated in the provision were simply too costly for homeowners. So they the appellate court put life back into the plaintiff's case by invalidating the arbitration clause and allowing Ms. Bain to continue with her lawsuit. Similarly, the next case I'm discussing is Continental Homes of Texas versus Perez. This is a 2022 case out of the Texas Court of Appeals. Here, the court considered whether the lower court properly invalidated an arbitration clause in a residential construction contract. Here, the plaintiffs hired the defendant, Continental Homes of Texas, to build a new home in San Antonio. The defendant provided its standard contract, which included a binding arbitration clause. No surprise there. The clause stated that every potential dispute between the parties would have to be administered and conducted by the American Arbitration Association. The clause also stated that the costs of the arbitration were to be split amongst the parties. The Perez's instead filed a lawsuit for alleging defects in the foundation of the home. The defendant filed a motion to compel arbitration pursuant to the contract. The plaintiffs here argued that the arbitration clause was substantively unconscionable because they could not afford the cost of arbitration. They argued that the costs of the arbitration through the AAA were higher than the cost of litigation. They submitted an affidavit explaining their monthly income. Their attorney submitted an affidavit stating that based on his experience with the Arbitration Association, the cost of arbitrating the subject dispute would cost over $10,000 per party, not including attorney's fees. That's just the administrative fees for using the forum. The Perez's also provided resumes of about 20 arbitrators from AAA whose costs were an average of $2,000 per day, which is way more costly than the court fees in litigation. The attorney also stated that in his affidavit that he agreed to a monthly payment plan for his hourly fee, which made litigation considerably lower than the cost of arbitration as set forth by the contract. The appellate court noticed noted that Texas precedent established that the factors to consider are the party's ability to pay the arbitration fee, the actual amount of the fee in relation to the amount of the underlying claim, and the cost differential between arbitration and litigation for that actual plaintiff. The court further explained that a comparison of the total costs of the two forms is probably the most important factor in determining whether the arbitration form is an adequate and accessible substitute to litigation. The court found plaintiff's evidence actually compelling. They applied heavy weight on the attorney's affidavit explaining his experience with AAA and the associated costs. The court also considered the plaintiff's monthly income and liabilities, which left the plaintiffs with little money to spare after the end of the month. The court also relied on the evidence of the attorney's agreed monthly plan, which made litigation far more affordable. The court ultimately found that the Perez's could not realistically afford arbitration and thus held the arbitration clause to be substantively unconscionable and unenforceable. This case, as well as the Illinois case, shows that there are protections against unconscionable arbitration provisions, and that if the arbitration agreement is substantively impractical because it makes it way too costly and more expensive than litigation, there is an argument that the arbitration clause should not be enforced. Now, in conclusion, it is unclear how these holdings would affect a subrogation claimant, since the subrogating insurance carrier has bigger pockets and has the means to incur arbitration expenses. Nonetheless, a subrogation professional needs to argue, particularly in these jurisdictions, that they step into the shoes of their insured, and that any arguments regarding unconscionability that would apply to the insured should also apply to the subrogating carrier. So it's important to know that these legitimate challenges are out there. And when you are confronted with an arbitration clause and litigation is the preferred route, these cases need to be considered. Thank you very much for your time. Can't wait to see you guys next time. And thanks again for joining Subro Sessions.
Thanks for listening to this episode of Subro Sessions. Be sure to check out our upcoming episodes. You could find past episodes of the podcast and relevant case updates on the Subrogation Strategist blog, all available at whiteandwilliams.com.